number 116670, State of Kansas versus John Christopher Harrison.
Good morning, I'm Rick Kittle and I represent the appellant, Mr. Harrison, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved.
This case involves Mr. Harrison's conviction for battery on a law enforcement officer, interference, and some traffic offenses after a jury trial. And one of the issues raised in his direct appeal from conviction was a challenge to the procedure used by the district court in responding to a question asked by the deliberating jury. Mr. Harrison specifically requested that he be present when that response was communicated to the jury, but the court said it was too late for that. He was found guilty of these charges at trial. The direct appeal to the Court of Appeals raised 4 issues. After the appeal, Mr. Harrison's convictions were affirmed. Both parties filed petitions. And this court granted review on a single issue, the single issue involving the manner in which the trial court responded to the jury's question. So what happened in this case? During deliberation, the jury asked the question, may we have the definition of battery and bodily harm? And after a discussion between court and counsel, everyone apparently came to a conclusion that this was going to be, we had a response that we're going to give to the jury. And the court announced that the response that would be given to the jury, this was outside the presence of the jury, was the instructions you have been provided as the law you must apply in the case, no further instructions will be provided. Now, in the trial transcript, immediately after that, on the same page, the prosecutor at trial says, look, there have been a number of appellate cases dealing with this issue, how a court responds to a jury's question. So should we consult Mr. Harrison and see if he wants to be present or if he's waiving his right to be present when that response is given to the jury? The defendant, Mr. Harrison, consults with his counsel, and then defense counsel says that Mr. Harrison would like to be present when the response is communicated to the jury. The court then immediately says, well, it's too late for that. I've already sent the written response back. And the court says, well, you know, if they ask any further questions, I'll make sure that we do this in your presence, but it's too late to accomplish what you're asking. And we are arguing that procedure, particularly with the fact that the defendant affirmatively asserted a right to be present, was error. Now, it appears in this case that the state is relying upon a statute case, a 2014 SUP 223420, which in pertinent part reads, the court shall respond to all questions from a deliberating jury in open court or in writing. And if I understand the state's argument correctly, they're basically saying because the court responded in writing to the jury's question, the statutory obligation is fulfilled, and so there's no problem. First, I'd like to point out that I think we're just assuming that that is what happened. Clearly, the court wrote down something on a piece of paper because the court referred to that. But as to how exactly that was communicated to the jury, we don't know. We're assuming that somebody, a courier, a bailiff, took the note to the jury wherever the jury was and gave it to somebody. But we don't know that for a fact because we don't have that in the record.
The judge said that he sent it back.
He sent it back.
And that's, okay, so that seems to imply somebody else took it back.
Right. And I'm thinking that's what happened too. Somebody took it to the jury. But what happened when that person got to wherever the jury was, we don't know. We don't know if he gave the note, the written response to one juror. We don't know if all of the jurors saw it. We don't know if the courier read what was on the note to the jury. All of those are possibilities. And that's the inherent problem with this procedure, because the actual communication between the court and the jury takes place outside the courtroom, and there's never any record being made of what actually was said or what actually happened.
Let's narrow down what we're talking about. You're not claiming a violation of the post-2014 version of 223420D, right?
What I'm claiming is that statute exists as it exists, but that's not the only law that needs to be considered regarding a defendant's right to be present.
What statute was violated by these facts? I want to set aside the constitutional. It seems like that we've either got a statute problem, a constitutional problem, or perhaps both. I just want to know what silos we're in for purposes of thinking about this case.
223420, if you look at it, nothing in the language of that statute in any way curtails any right a defendant has to be present. There's nothing in that statute that says a defendant does not have a right to be present when the court communicates with the jury.
That's not the question I'm asking. I'm asking whether this statute gives the defendant a right to be present when the note is delivered to the jury. That's what I'm asking.
Okay, well then I would say...
Because it used to, and I don't think it does now. But I want to hear what you have to say about what it does now.
Okay, let me address
the argument the state's making.
Let me address what I think the law is that provides the right to the defendant, if I understand your correct.
No, my question is whether I can read this statute and find a statutory right for the defendant to be present when the note is given to the jury.
The statute doesn't specifically state that.
Okay, that's what I'm trying to get at.
Okay.
It used to, now it doesn't.
Right.
Right?
Correct.
Okay.
Okay. But if you look at the statute, it also doesn't say anything that the defendant doesn't have any right. It's not depriving him of any right that he might have to be present. And if you look at KSA 223405, 2017 says the defendant in a felony case shall be present at the arraignment at every stage of the trial, including the impaneling of the jury and the return of the verdict, and at the imposition of sentence, except as otherwise provided by law.
What does he have the right to be present for in your scenario? The note can be delivered. Does that mean if he exercises, this is in your interpretation, a right to be present, does he or she does the defendant get to go back to the jury room to see how it's handed? Does he have a right to witness it being read to the jury or how the foreperson handles the question? What does right to be present mean in your scenario or in your...
Well, obviously, he's not going to go back to the jury room and interfere with what's going on in the jury, because I don't think anybody has a right to go in there and see that. That's the problem I have with 223420. I think that the law says, I would say the law indicates that a defendant has a right to be present anytime a court is communicating with a jury. Okay? Now, what does that mean for the defendant in this scenario? If you look at 3405, it says that the defendant has a right to be present at the impaneling of the jury. Well, what does that mean? I mean, it could conceivably mean the voir dire, because that's part of how the jury is selected. It could conceivably mean the point at which a potential jury is sworn, or the point at which the final jury is sworn to hear the case. It could mean the exercise of peremptory strikes. Now, typically, in all of those situations, a defendant is not going to be standing up and objecting or interjecting something. He's just going to be observing. But the law indicates he has a right to be present during that. And the law also indicates that the defendant has a constitutional right to be present anytime his presence is going to contribute to the fairness of the proceeding. And if impaneling of a jury, if he has a right to be there at the impaneling of the jury, when he's not going to be saying anything, it has to be because it contributes to the fairness of the proceeding. It's his trial. It's a constitutional right that he has.
So as I understand it, you're boiled down, your argument is that 3420D is unconstitutional.
I would say if it's being interpreted that you can simply deliver a written note to a jury in the jury room outside the presence of the defendant, then yes, that's a violation of his constitutional rights.
And that is what the statute says, isn't it?
I don't think so, because it doesn't do anything that says the defendant doesn't have that
Well,
right.
what about the following sentence after open court or in writing, which then says the defendant must be present during any response if given in open court? Doesn't that at least imply that when it's done in writing, the defendant does not have to be present?
Well, I think there's also language in that statute that talks about waiver.
Right, it says the defendant must be present during any response if given in open court unless the presence is waived.
And
But the language "if given in open court" clearly refers to the prior sentence, which says "in open court or in writing."
that's correct. But one thing I'm thinking is that the language of waiver in that statute is an indication of how important this right is. And I realize it's talking specifically about a conference between court and counsel about...
It's talking about if the response is given in open court.
Right. But to interpret that statute that way completely ignores the other statutory law that provides for a defendant's right to be present.
So let me jump to that for my other question, which is, doesn't the tail end of 3405, which says except as otherwise provided by law, potentially at least, permit 3420 to be the overriding statute as otherwise provided by law?
You have to look at statutory law, you have to look at case law that's interpreting the Constitution.
Sure, I'm just asking about the statute.
Well, I suppose it could be interpreted that way.
And if it is, your argument would be that's unconstitutional.
Right.
Okay.
Before you run out of time, I want to get at your supplemental brief to the court after we granted review. Set the statute aside. Let's just talk about the Constitution, the Sixth Amendment and the Fifth Amendment rights. Those are federally stated rights. Are you aware of any federal case law that says it's a violation of the Fifth or Sixth Amendment to simply deliver a note to the jury, assuming that the defendant's been present while the note was being composed? There's none of those other issues. We're simply talking about the delivery. You didn't cite us to any federal cases in your brief. The state did, and I just wonder whether you're aware of any that support a constitutional right to be present when the note is handed to the jury.
I'm not aware of anything with that specificity, talking about delivering a note to the jury.
But there are federal circuit cases that are specific to that set of facts that
Right.
find the other way.
Right.
Okay.
And I would simply say that if the law, which I believe is part of the controlling law, is that a defendant has a right to be present whenever his presence is going to contribute to the fairness of the proceeding, should apply here.
How does it contribute to the fairness of the proceeding?
Well,
For the defendant to be present when a note is handed to the jury. That's your argument.
well, I guess I would look at it this way. And I'm sorry I'm going over my time. I'll try to answer this question as best I can in the time that I'm given. What we're talking about here is basically an instruction being given to the jury. Now, granted, it's happening during deliberation, but it's the court instructing the jury on the law or the facts.
The delivery of a communication that the defendant has already contributed to the composition of.
Okay, how would it have affected in this case? If instead of just giving a note, well, let me put it this way. If you were a juror in this case and you received this answer that was given to the jury, what would you think? The answer was, and I'm not objecting to the content because I can't. It wasn't objected to below. This was something that everybody agreed on. But what would the juror think if they got the note that said, the instructions you have been provided is the law you must apply in this case. No further instructions will be provided. There's nothing in that response that is keyed to the actual question that was asked. So a juror getting that response could reasonably interpret it as saying, there's no point in us asking any further questions because the court has told us no further instructions will be provided.
The defendant's presence when that note gets delivered, doesn't do anything to contribute to how the jury processes that information. Are you trying to say that the defendant has a right to inquire as to how they're feeling about, what they just were told?
What I'm saying, Your Honor, is if the court was required to read that response in open court to a jury, somebody might say, well, that doesn't sound right. That doesn't really sound like what the message that we intended to convey. Clearly, the court was not foreclosing any further questions by the jury, because that's what the court told Mr. Harrison. If there are further questions, we'll make sure you're present when they're asked or when the response is given. But if that response had been required to be read to the jury in open court, perhaps somebody, maybe the judge, maybe one of the litigants, maybe one of the jurors would have said, well, Your Honor, does that mean we can't ask any further questions because we're absolutely not going to get any further instructions from you? So that's one of the reasons why we need to have these things read aloud on the record, so everybody has a chance to observe and hear with their own ears and see with their own eyes what's going on.
So your argument is the defendant, that questions from the jury can't be answered in writing, period. They have to be answered in open court where everybody can see what's going on, because that's different than arguing just about whether the defendant gets to be in the room when the note is handed to them.
Right. My argument is that if the use of a note is going to somehow impinge on any right the defendant has to be present at a critical stage of the trial when the court is communicating with the jury, then that is a violation of his constitutional rights.
Do you know of any case that's found such a constitutional violation when the answer is essentially telling the jury, the question is, whatever it is, and the jury's, and the agreed response is, I'm not going to answer that question. It's a non-answer, isn't it? It conveys no new information.
Right.
He's saying, I'm not going to answer that.
Well, to answer your question, no, I'm not aware of any case law. And I think at one point, in discussing this matter, the court said, well, this is a non-issue. If the jury was here, all I would do is read them what I wrote on that piece of paper.
Well, that's the way it's communicated, but I'm talking about the substance of the communication, which is basically, I'm not going to answer the question.
Well, that would create a different problem, because I think a court has an obligation to at least try to answer the question asked, even if it means we can't give you any further information.
Are there other questions? Thank you, counsel.
Thank you.
Madam Chief
Gonteski.
Justice, may it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the cross-appellee, the state of Kansas in this case. The state of Kansas specifically cross-appealed on the issue of the Court of Appeals finding error here on this issue, while the Court of Appeals affirmed Mr. Harrison's convictions in part because they found this error to be harmless. The state cross-appealed because this should not have been found to be error at all. Under the new statute that was amended before Mr. Harrison was ever arrested, much less brought to trial in this case, the statute made clear that the court's procedure allowed for either responding to a jury's question in open court in the presence of the defendant or in writing. The state's argument here is that that statute is clear on its face when it allows a response to a jury question to be made through writing that is sent back to the jury room outside the presence of the defendant, as long as the defendant was present when the response was formulated between the parties in court.
You would certainly agree that if the Constitution goes the other way, the statute can't stand in the face of that.
Absolutely.
And the Court of Appeals essentially, as I read it, said it was bound by our decision in King.
True.
So does that mean, it sounds like you're effectively asking this court to overrule King's constitutional holding.
In King, I believe the overarching theme in King was interpretation of the statute, and there was some discussion that went along with that it could implicate constitutional rights.
Well, do you think the Court of Appeals misunderstood King?
No. I think they applied King as they felt duty-bound to do, although King interpreted the old statute.
But they referenced King's constitutional holding.
They
Did
did.
not?
They did, and to the extent that they referenced that, I don't believe as though that was a correct interpretation of King.
But it isn't, to your point though, wasn't King based on the fact that King, the statutory interpretation in King was that the defendant had a right to be in open court under the statute?
Correct.
And that if there is a statutory right to be in open court, then there is, that then constitutionally gives the defendant the right to be present if everybody else is in the courtroom.
Yes, absolutely.
And that's not, as I understand it, that's not your interpretation of the current statute. That
Correct.
There is no statutory right to be present in the courtroom, and thus there's nothing that gives rise to that constitutional right that was at issue in King. It seems to me that perhaps the Court of Appeals didn't put it in that context of that right initially arises as a statutory right under King. And then, like I said, if everybody else has a right to be in the courtroom, I think constitutionally, that the King is saying constitutionally the defendant should also be there.
You said it better than I could have, absolutely. King was interpreting the old statute, and the old statute was really the cornerstone of that opinion. And frankly, opposing counsel said here today when he spoke about the statute, and said the problem he had with it in speaking about the application of it. Both at the Court of Appeals below and in the defendant's petition to this court, he repeatedly cited to the old statute and never referenced the new one. I repeatedly brought back the discussion to the new statute because it's the one that's applicable here. So all the discussion of King and Coyote and these other cases that came before, while instructive to a degree on the interpretation of the statute, are not controlling when those cases all interpreted the old statute, or in the face of the new statute, I believe in the Bowles-Son case in 2015, after the statute had been amended, the state had conceded error in that case, even though the statute had been amended, in my belief, in the state's favor. But the state had conceded error, and so the only argument was really about the harmlessness. There was no actual analysis of whether or not it was error to respond to a jury question in writing. So the question that came up earlier about which statute governs here, 3420, talking about the procedure and responding to jury questions, or the broader statute that calls for a defendant's presence during critical stages and so forth, I would argue that 3420 is what controls this particular procedure, given that it is the more specific statute pertaining to how to respond to a jury question.
Am I correct that, I mean, in your I know what you cited in your brief, but am I correct that there are no federal cases that have constitutionally invalidated the procedure of sending a note back to the jury, assuming that the defendant and defendant's counsel knew about the question and got to participate in the formulation or the composition of whatever is said?
I found no federal cases that instilled that right constitutionally to a defendant. I would have felt duty-bound to put that in my brief, particularly given that I was citing to the Second Circuit and the Eighth Circuit opinions that held the other way. I was citing to all the opinions I could find that spoke directly to the procedure that was utilized here, which was responding in writing to the jury is permissible constitutionally. That's why I cited to those propositions. I found no research, no results to the contrary. The argument that's being made here today, to the extent that the defendant now argues that 3420D is unconstitutional, I don't believe as though that's before you. That was never raised below. That was never raised at the district court. It was never raised at the Court of Appeals even. The Court of Appeals addressed whether or not this violated the statute and the Constitution, but it did not answer the question about the constitutional validity of 3420 subsection D. I argue it's absolutely constitutional, but that aspect of this argument has never been made before today. The speculation about how this response could have been communicated to the jury or not by the foreperson, if it was handed to one, if it was read to all, if it got communicated fully. In this case in particular, my response to the harmlessness argument, I obviously still hold on to, and that given that the nature of this response, not substantively giving any further guidance than had previously been provided, shows that it was harmless. But if we are going to start venturing down the path of asking about potential problems about how it could have been communicated in the jury room by the bailiff, or if the note was provided to just the foreperson, and if the foreperson read it or not, if the foreperson tossed it without communicating it to the rest of them, and so on, we start venturing down a path of presuming, or at least assuming, some sort of misconduct is going on in the jury room. And if we want to presume as much, the entire ability for a jury to deliberate on their own in a jury room, just the 12 of them, very, very quickly falls apart if we're going to presume this type of misconduct or this type of error is occurring between the parties just in the jury room themselves. I still haven't heard how the defendant's presence is necessary to contribute to the fairness of this type of procedure. I can't conceive of, nor have I heard any arguments that demonstrate how it would be more fair for the defendant for the judge to convene all the parties in court, call the jury back from the jury room to be seated, call the court reporter in and the bailiff in, and to read to them, please refer to your existing instructions. No further instructions will be provided on this point of law. I can't conceive of a scenario in which the defendant's presence there is necessary to contribute to the fairness of that communication. We're not talking about a dialogue here or a portion of a trial in which either party is even allowed to argue anything. We're not reopening anything. The defendant was present with counsel, with the state present before the court when the parties put together the response and when they agreed upon the substance of that response. That portion of this procedure, the state agrees, requires the presence of the defendant. He has a right to be present there. To the extent that opposing counsel cites to the defendant's right to be present during other portions in which he cannot speak or participate, such as impaneling a jury, a defendant's presence is necessary during the impaneling of a jury because he's sitting with his counsel and presumably assisting his counsel, or at least chiming in to his attorney in reacting to, responding to how a jury is speaking up during jury selection. When both the state is before the jury panel and defense counsel is before the jury panel conducting voir dire, there are responses and all sorts of dynamics going on there in which the defendant's presence is understandably necessary so that he can properly advise his counsel who we should strike, who we should seek to keep, who we should object to if the state tries to remove, and so on. So impaneling a jury is entirely a separate portion of a trial which understandably necessitates the defendant's presence from the scenario that we have here in which the court is responding to a question by providing an agreed upon response to the jury that essentially just points them back to their existing instructions. If we had a procedure in which counsel could debate the merits of the response before the jury, then absolutely the defendant should be present. If we had a procedure whereby the response could be communicated to the jury and then the jury could go in a dialogue back and forth with the judge to get more clarification, then the defendant's presence would understandably be necessary. That's not what we have here. We have no such procedure at issue when all the court is doing is providing an agreed upon response to the jury. The defendant's presence during that process contributes nothing to the fairness of the proceeding. That's why his presence isn't necessary. That's why it's not error at all for him to be absent when that communication is relayed to the jury. There are other times where the district court, or at least through the bailiff, likely corresponds with the jury. Should we order lunch? Are you staying long enough that we need to order dinner? Do you want to stay longer into the evening, or do you want to wrap up now and return in the morning? There's all sorts of communications that happen between a bailiff and the jury where they don't happen in open court or in the defendant's presence. And they're permissible because those types of communications don't contribute to the fairness of the proceeding in a manner in which the defendant's presence is necessary to ensure that fairness. So what we have here is a procedure that both adhered to the statutory dictate that was applicable to this case and certainly respected the defendant's constitutional rights to due process and everything else when he was in that courtroom. When we go back to 2017, State versus McDaniel, critical stage was defined by this court as any stage when a jury is in a courtroom or when the defendant's presence is essential to a fair and just determination of a substantial issue. There's nothing essential about the defendant's presence here when this communication is relayed back to the jury. The jury was not in the courtroom when this was relayed, so it was not a critical stage. My harmlessness backstop and my response to the defendant's petition for review that was granted in this case, which was on the harmlessness prong. There's 4 factors there. I briefed all the 4 factors about the strength of the state's case. The strength of the state's case was overwhelming here when we had 3 different camera angles that showed the defendant battering 2 police officers on the side of the road that day. We have body cameras, we have dash cameras. There was cell phone video taken from a citizen standing nearby. Multiple angles showed everything that happened in this case, and the evidence was absolutely overwhelming. The defendant did object to this procedure when the state flagged it as an open issue in the appellate courts, but his objection shouldn't carry the day in resolving the harmlessness issue. Whether the communication was on a critical aspect is the 4th prong of the harmlessness analysis in this case, and it absolutely was not, given the substance of the response and the post-trial ability to mitigate any error. I would argue there essentially was no error to mitigate here, because all that could have been done, if we run this to its conclusion, is to inquire of the jury after a verdict, did you all receive that note from the court when the court responded that it was providing no further instructions? And either they will all say yes, in which we would conclude no error ever happened because they all got the response. Or perhaps one would say, no, I didn't get that. I didn't hear that. In which case, presumably then, they would have gone on to decide the case with the existing instructions, which was exactly what the note told them to do. That's why it would be harmless. So the state is asking that you affirm the courts below that affirmed Mr. Harrison's convictions, although I would ask that you reverse the Court of Appeals finding that this procedure was error at all.
Thank you, counsel.
Thank you.
One of the things counsel said was that the issue raised here invites speculation as to what happened in the jury room, how the note was delivered, whether everyone saw the note. But of course, that kind of speculation is not going to occur. The only reason it might occur is because things are happening outside the courtroom off the record, and there's no way to tell exactly
Counsel,
what
let me ask you this. Judge Sutherland does everything that he did in this case. The answer is we're not going to answer the question. Everybody agrees to it. Defendant's present. They write that down on a note, put it in an envelope, and seal it. They go back out in the courtroom. The judge has the bailiff hand the sealed envelope to the jury foreman and says, you can all open it when you get back in the jury room. Has the Fifth or Sixth Amendment been violated by that?
if the constitutional right applies to that the defendant has a right to be present at any communication between the court and the deliberating jury, I would say that's not proper, because the actual communication does not take place until the note is read, wherever that happens, in the courtroom or outside the courtroom.
How can that be the law? I mean, where is that the law? That the Constitution requires the jury to read the note in the presence of the defendant.
Well, I don't know if there's any law that specifically says that, but
Well, that's what you're saying, right?
What I'm saying is the constitutional law requires presence when there's a communication. And the communication implies some sort of imparting information. And the information is not imparted until the jury actually reads what's on the note.
Counsel, perhaps I can shed some light on this. In King, as far as I can tell, we analyzed a fact pattern that for all practical purposes is identical to what we have here. Note delivered by judge back to jury. And the King court said that process, and I'm quoting here, violates the guarantee of the Sixth Amendment to the United States Constitution that a criminal defendant be present at every critical stage of his or her trial. If we apply King, don't you win on the error
I
issue?
think so. And I would also note that there's been discussion, one of the things counsel talked about was the 3405 statute and how it provides a right to the defendant to be present at every critical stage of the trial. But the statute doesn't say that. The statute actually says every stage of the trial. It doesn't say every critical stage, it says every stage.
But the constitutional issue at King is the critical
Right,
stage.
I understand that.
And that ties then back to the definition of critical stage, which is that if there's open court, then the defendant has a right to be in the courtroom.
I'm not
And this-
disputing, I'm
and-
sorry.
And at least as I understand King, that's the basis for that statement in King, is because the statute was interpreted in King to require the presence of the defendant in the courtroom.
I'm not disputing any of that. I'm just
So
saying,
if we interpret the statute not to require, the current statute not to require the presence of the defendant in the courtroom, King doesn't apply here, does it?
I wouldn't go that far, no, because, well,
Is it possible for a statute to change the Sixth Amendment's requirements?
no, I think the Sixth Amendment requires what it requires. And it's not going to override what the constitutional law says.
No, but the statute can trigger the Sixth Amendment by by statutorily requiring the defendant to be in the courtroom, or saying that the procedure would require the defendant to be in the courtroom.
Maybe I missed the question there.
Well, if the prior statute said this will occur in open court, and our definition of a critical stage is that if its court is open, defendant has a right to be in the courtroom. The McDaniel quotation that Mr. Gonteski read to us, I think, is a fair definition of that. Aren't we connecting those dots that's what gives rise to, under the prior statute, for the defendant to be present? Constitutionally and statutorily?
Well, in this case, I'm arguing there's a right for him to be present in this situation, both constitutionally and statutorily. And I would note that this court in Calderon basically said a defendant's right to be present extends to any stage of the criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the proceeding. I think any time the court is communicating with the jury, that's a critical stage of the trial. It's certainly a stage of the trial. It's a critical stage of the trial and requires the defendant's presence. And I'm way out of time. I do have one other analogy I wanted to make, but if I would finish unless the court grants me some
Any
indulgence.
communication with the jury, that means when the judge says to the bailiff, go in and ask the jury if they want to break for lunch now,
Well-
or whether they want to continue on for another hour or so.
I'm not extending it to that. I'm talking about any communication that deals with the facts or the law of the case, telling the jury how it's going to proceed in trying to reach an outcome in the case.
Other questions?
Thank you.
Thank you, counsel. I thank both counsel for their arguments on this case. The court will now take the matter under advisement.